Welcome to this explainer. You know, right now, artificial intelligence is out there doing incredible things. It's writing contracts, it's answering customer support questions, it's even drafting complex legal briefs. But what happens when it just confidently lies to you? Because occasionally that's exactly what it does. It invents facts, it fabricates case law, and it delivers completely false information with absolute unwavering confidence. So today, we're going to explore exactly why this happens, look at some massive real-world lawsuits, and most importantly, answer the multi-million-dollar question. When an AI hallucinates, who actually pays the price?
So let's start by pinning down exactly what we're talking about here. An AI hallucination isn't just a technical glitch, and it's certainly not a simple typo. It is a confident, wrong answer generated by an AI system. The thing is, the system isn't lying on purpose. It's just predicting the next likely word in a sentence based purely on statistical probability, rather than verified facts. It's not an honest mistake that the system is self-aware of. It is a highly confident, perfectly polished, yet entirely fabricated response. And because it reads so beautifully and smoothly, users completely trust the output. And well, that is exactly where legal liability begins.
Here is our roadmap for this explainer. We're going to cover 1. The confident liar. 2. Why AI hallucinates. 3. The legal fallout. 4. Who is legally liable. And 5. Reducing your legal risk.
All right, diving right into part 1, the confident liar, and what happens when the machine guesses wrong.
The absolute most crucial thing to wrap your head around is this. Generative AI optimizes for fluency and coherence. It does not optimize for truth. Think of AI like a really eager, highly confident intern. It doesn't actually know facts the way you or I do. When it lacks reliable information on a topic, instead of just admitting, hey, I don't know the answer, it just guesses the most plausible sounding next word to fill the gap. It desperately wants to give you a coherent sentence, even if that sentence ends up being a complete work of fiction.
Which brings us to Section 2, Why AI Hallucinates, looking at the technical causes.
There's a massive fundamental divide between human cognition and machine cognition. Human knowledge relies on verified facts, memory, and an actual grounding in reality. AI generation, on the other hand, relies purely on statistical probability and pattern prediction. It's not cross-checking its thoughts against reality. It's literally just calculating the odds of one word following another.
So, what actually causes these hallucinations? It's a perfect storm of technical flaws working together. First, when AI learns from incomplete or biased training data, it just invents content to fill the gaps. Then, its overconfidence in pattern prediction means a totally fabricated sentence is going to sound just as authoritative as an accurate one. Couple that with a lack of real-time fact-checking, since most models aren't verifying claims against live authoritative sources, and you've got a massive blind spot. Throw in ambiguous or leading prompts from a user, plus commercial models optimizing for speed over deep consistency, and you've got the perfect recipe for producing fabricated case citations or totally false medical guidance.
Let's move to Section 3, the legal fallout, or as I like to call it, high-stakes courtroom drama.
Let's walk step by step through the infamous Mata versus Avianca case. This started as a routine personal injury claim, but it quickly became the defining cautionary tale about AI hallucinations. 2 New York attorneys decided to use ChatGPT for their legal research. The AI, playing the role of our confident liar perfectly, completely invented an alternate legal universe. We are talking 6 totally fake cases, fake judges, fake docket numbers, and completely fake quotations. The lawyers blindly trusted this output and submitted the brief to federal court. The result? The judge slammed them with a $5,000 sanction for failing to verify their sources.
And here is the wildest detail from that whole disaster. The lawyers actually got suspicious at one point. So, what did they do? They asked ChatGPT to verify if the cases were real. And ChatGPT, of course, confidently affirmed that they were absolutely genuine. This proves a vital rule you have to remember. You cannot ask a fabricating system to check its own work because it has no independent way to access reality.
Let's look at another wild example, this time involving Air Canada. A passenger asked the airline's official chatbot about bereavement fare policies. The chatbot completely hallucinated a false refund policy that directly contradicted the airline's actual rules. When the passenger sued, Air Canada tried to argue, incredibly, that the chatbot was a separate legal entity responsible for its own actions. The tribunal completely rejected that. As this quote perfectly captures, a company cannot escape responsibility simply because a machine, rather than a person, produced the false content. The chatbot is part of their website, so the company is fully liable for negligent misrepresentation.
Then there's the massive risk of reputational damage, like we saw in Walters versus OpenAI.
In this case, ChatGPT generated a completely false summary alleging that a real radio host, Mark Walters, had embezzled funds. Just a totally fictitious claim out of thin air. Walters sued for defamation, but the court actually dismissed the claim. Why? Because OpenAI had very clear disclaimers warning users that the system might produce false information, and there was no proof of actual malice or damages. This perfectly highlights the limits of suing the developer instead of the user.
Okay, Section 4. Who is legally liable? Let's play the blame game.
When it comes to who actually writes the check, liability generally falls across three main parties. First up, the deploying company, like Air Canada. They face high liability because they control the customer-facing tool and treat its output as their own official communication. Second, the professional user, like those lawyers in the Veda case, or doctors or accountants. They also face high liability because they owe an independent duty of care to verify information for their clients. And finally, the AI developer or vendor, like OpenAI. They often face much lower liability. As long as they plaster the tool with explicit warnings and disclaimers about hallucinations, courts are generally shielding them from the actions of the end users.
Depending on the flavor of the AI's mistake, plaintiffs are aggressively using established legal theories to attack these failures. They're suing for negligence when consumer-facing bots give bad advice. They're trying defamation for false statements about real people. There's breach of professional duty for lawyers who don't verify their citations. We are even seeing product liability lawsuits framing hallucinating tools as defective products, or breach of contract when a chatbot's false promises act as a binding offer that the company is forced to honor. The law is adapting incredibly fast here.
Regulators are definitely catching on globally too. This isn't just viewed as a technical bug anymore, it's a recognized governance risk. In the US, the NIST AI Risk Management Framework directly defines these hallucinations. They call them confabulations and gives companies a method to manage that risk. Over in Europe, the EU AI Act imposes strict transparency and safety rules on high-risk AI deployments to prevent these exact fabrications. And consumer protection agencies worldwide, they're treating misleading AI outputs the exact same way they treat false advertising.
All right, Section 5. Reducing your legal risk with actual strategies for mitigation.
Before you use generative AI to draft your next contract or customer policy, here is your actionable checklist. First, grounding your AI in verified data through retrieval augmented generation, or RAG, is absolutely critical. This forces the AI to look at your specific verified knowledge base before it answers. Second, you must have clear, highly visible disclaimers in the user's path. Third, and guys, this one is non-negotiable, mandate human review for any high-stakes outputs touching legal, medical, or financial matters. You also need to continuously monitor the outputs and document your good faith efforts to build safeguards. Doing this proves to a court that you took the risk seriously.
Now, a quick, crucial note for any legal professionals tuning in. You have to go a step further. You simply cannot rely on general-purpose chatbots. You should exclusively use specialized tools tied directly to verified legal databases. And even then, as we learned from the Veda disaster, you must independently verify every single case citation, statute, and quotation before filing anything with a court. Your professional license literally depends on it.
So, at the end of the day, we've seen that AI is incredibly powerful, but it can also be a highly confident liar. The core takeaway from all of this is simple. Confidence is not the same thing as accuracy. Trust in AI output must always be paired with rigorous human verification. Which leaves us with one final urgent question for you to consider regarding your own daily workflow. Is your AI assistant a tool or a liability? Thanks so much for joining us on this explainer.